Hi Neil, hope you're well. I really appreciate that you're able to help me out on the few problem debts we're having trouble collecting. I don't think any of the three companies involved have valid reason for not paying, and it's really crippling our cash flow, especially with the payroll due to be run next week. I look forward to our meeting. Best regards.
Good morning, Rod. Thank you for your email and for coming in today. I gather you've got a few problem debts you'd like us to have a look at.
Oh, I have indeed, Neil. We've got three particular debts. We've got our cash flow running at the end of the month. In fact, it's just a couple of weeks now, and we need cash in. And these three debts have been outstanding for some time and are quite significant.
Well, let's look at the first one. Is that Cameron Construction
It
Limited?
is, yes. I've got the papers here for you. Cameron Construction's the first one.
Okay. Right. Well, what can you tell me about them?
Well, we've been owed £85,000 for work carried out between September and December. There's about £57,000 that is not in dispute, and I've got an email from the director of the company confirming that. He's quibbling about some defective work or remedials, which is about £3,500. The last invoice we sent through was for about, I think it was about £18,500. And what he's saying there is that we sent it in too early, and that his QS hasn't signed off the workers yet.
Right.
So I'm quite relaxed about that, but I do want this big chunk in because he said there's £57,000 that's due and owing, and when I've asked him to make payment, he's just blanking me.
So he's saying that because he's due a credit note for a small amount, he's not going to pay that large amount of 57,000.
I know it sounds stupid, but really that's what he's saying to me.
But he's admitted in an email that 57,000 is due and owing.
Oh yes, it's in the papers there. He's clearly stated that.
Okay. Well, that's something where we might need to consider going in very hard and very tough. There's a number of options, but if they've really got no excuse, they're just simply not paying, we might consider the threat of a winding up petition, which really is the nuclear deterrent of all debt recovery procedures.
Okay, well I'm happy with that because the other directors want me to get this money in quick, and it's potentially my fault that we've let this one slip.
Okay. Well, a threat of a winding up petition can be extremely effective in the right circumstances, and you've got to be clear. The money's got to be generally undisputed. It's just something which is quite clear. If there's any dispute, it shouldn't be gone down through that route. And basically what you do by that is all of a sudden, by the threat of a winding up petition, you become top of the debtor's list of priorities of things to do. If you just say, well, we might issue a counter court summons or claim form, then they'll probably say, yeah, I will deal with that as and when. But all of a sudden you're putting at threat the potential continued viability of that company. It is high risk. If you get it wrong, then you could be penalised in costs. But certainly, if you're talking about a situation where, particularly if there's rumours about whether the debtor is able to pay and they're not paying other people, you want to say, right, we are now your most pressing problem.
Well, you may be right there, Neil, because I've heard rumours about the company, and I know some of their own debtors have gone into administration. They've told me one or two of their customers have not paid up and have gone pop. So I'm just worried about them as well, but I do need to get this money in quick.
Okay. Well, I'll tell you what we'll do is I'll look through that file of papers, go through. I'll prepare a letter which will basically say, and I'll run it past you for approval, will say, if you don't pay, the money is clearly due and owing, you've admitted the debt for at least the undisputed element. If we don't receive that in cleared funds within 48 hours, we're going to present a winding up petition against them. And that will put them on the spot. So they've got to decide whether they've got any dispute. If they don't have any dispute, they don't really have any grounds to go to court to get an injunction to stop you from presenting that petition. They should know by then whether they're able to pay. If they're not able to pay, well, you'll know it sooner rather than later.
That's fine. I presume the letter's going to come from you.
The letter will come from me. I'll run it past you, and we'll send it to them, send it to their managing director and their finance director at the registered office, and it will make it pretty clear the consequences, what will happen if they don't pay.
Oh, great. That's brilliant, Neil. We can go on to the others now.
Okay.
Um,
Well, let's look at Miliband Marketing Limited.
yes. This is probably a sticky one here. With Miliband, they owe us about £36,000, and this goes back again to October. We've had no complaints, but suddenly when they've been chased this month for payment, they're saying the work was defective. They've had to get someone in to redo the work. They're going to be contra charges, and we ain't going to see a penny. Now, the only concern I've got is that the QS we had dealing with the work, the site supervisor as well, they've left under a bit of a cloud. What do you suggest we can do there, Neil? Because he's not saying what's defective. I'm getting no sense out of him again.
Right. So they're playing the game as it is. Well, what we can do, I don't think, given what you said, if you said there's some difficulties, potential difficulties, I don't think that the threat of a winding up petition is right for this particular circumstance, at least not at the moment. If you did that, as I said, the courts take a dim view as trying to resolve disputed debts through the winding up procedure. So what you should do is we should write to them, very strongly worded letter before action, set out that basically you say that the money is owing. As far as you're aware, there's no substance for any reason why it shouldn't be paid. They haven't done that. If they don't respond to that and put their side of the case pretty quickly, then you will then go through to the county court and issue a claim form against them, and we can proceed on that basis. Now, what I suggest you do is go and interview. You say the manager that ran the job has been dismissed. I think we need to go and get clear evidence from other of your team that were on the site as to how the job went, and if there are any complaints expressed while the work was going on. Certainly we'll put pressure on them to, if they say there's a valid reason for non-payment, to state that pretty quickly. Otherwise, we'll go down the litigation route and issue a claim form against them. But just to be clear, that case, I don't think, from what you're saying, is suitable for the threat of a winding up petition.
Okay, well, I appreciate that, Neil, because it looks like we may have to write that one off from our cash flow for the time being. The last one, I've got Clegg Contractors Limited. This is, well, I've known the bloke for a long time who runs the company, Neil, but I think it's almost like 20 years. Our kids go to the same school. And to be frank, he's been upfront with me. There's £28,000 owed. We have had discussions by telephone about the debt. Now, he's been frank with me and said they've got cash flow problems. They've got HMRC on their backs, and they've had to reach an arrangement with them, paying what they owe them off. And I've been there before years ago, so I know what that's like. But it's a chunk of money. He wants us to continue doing business, and I just want this money in, even if it's in instalments. Now, we can factor that into our cash flow, but I don't want to lose it. And I'd rather get something back than nothing, Neil, if his company's going to go.
Sure. Okay, well, you've got a client, a long-standing client who says in difficulties. You believe him. If you threatened winding up, you're likely just to simply tip him over the edge, and you weren't unlikely to get anything. The same token, if he's being straight with you, you probably, at least at this stage, don't want to issue legal proceedings against him. You say that you want to have ongoing trading, but you'd be concerned, you certainly don't want the position worse, you want to recover the position as best as possible. And you said that they've made arrangements with HMRC under a time to pay arrangement.
Yes.
Right. What I suggest very strongly, this is more of a practical issue rather than a legal issue, is you sit down with him, get him to open his books to you, get him to disclose what deal he's done with HMRC, and if he's paying them so much pro rata, you say, well, we would like to be paid pro rata in accordance with the same, on the same basis. So the same way that he's going to pay clear the HMRC debt down over time, he should be clearing your debt down. Now, as for ongoing trading, that's a difficult one. It may be that if you refuse to trade with him further, you're not at the top of his list of priorities. The same token, you don't want to make a bad situation worse. So you've got to work out some sort of plan by which he's going to pay you. If he wants to, I suggest you put him on a drip feed, maybe further supplies on a cash on delivery basis. And above all, what I would very much recommend is that if you reach a deal, get it all recorded in writing, make it clear that any concessions you give to him only last for as long as he meets his side of the bargain, and if he defaults further, all bets are off.
Right. Someone mentioned to me about getting a personal guarantee off him. Now, he is someone I know, and he may be prepared to do that. How do I go about getting a personal guarantee?
Well, you can certainly ask him for a personal guarantee. You've got to decide how much does he need you. Can he get his supplies from elsewhere? Well, you can certainly ask him for a personal guarantee, and that may cause him to think very long and hard. And also the advantage if he is prepared to do that, then it makes him more inclined, more incentivized to stick to his side of the bargain going forward, because he knows that if he defaults, his company defaults going forward, it won't just be his company you're after, it'll be him personally.
Well, Neil, that's been really helpful. Thanks a lot. What I need to do is give something to the directors. So if you could send something to me with bullet points, confirming what we've discussed, and with any draft letters, etc., then what I can do is, I think it's tomorrow, we've got a board meeting lined up in the morning. I can relay to them what we've discussed and then take matters forward.
Sure, I'll certainly do that. What I'll do is I'll send you an email. To the email, I'll attach some draft letters to each of the three debtors there, just so you'll make sure you're happy with it, make sure I've understood the position correctly, and then if you come back to me, and then I can arrange for those letters to be sent out to each of the debtors pretty quickly.
Well, that's really helpful. That's brilliant, Neil. I'll weight off my shoulders.
Okay. Well, thank you for coming in.
Today we have seen three scenarios, three very different debts and three very different debtors. From a winding up petition against a debtor who owes a large debt, the majority of which is not disputed, to a small and valued supplier where the options for recovery in part or in instalments would appear to be the way forward. The key points to take away from today is that no one option will apply to every debt. You must always be pragmatic and think about what you have done and whether you could do any more. Make sure you are in constant contact with your debtor and always consider possibilities for other methods of payment. Is it better for you to receive part payment or instalments rather than nothing at all? Above all, remember that your business's interests are paramount and that the debtor should be pursued robustly where possible, but in all cases pragmatically in order to recover wherever possible.